All right. Hello, everyone, and thank you for joining today's presentation and new webinar series brought to you by the SLW Institute, which was developed by the Schwegman firm to deliver educational and training content to advance your IP knowledge. My name is Brian Ness, and I'm facilitating this webinar series. Before I talk about this series and today's presentation, here are a few housekeeping items. If you have any questions during today's presentation, we encourage you to use either the Q&A or chat feature. Also, we'll be sending a follow-up email to each of you tomorrow that provides a link to the recording of this webinar and a copy of the PowerPoint. This webinar series is going to be presented by Schwegman's Chem and Biolegal team, and their goal is to provide practical tips to companies and universities looking for an understanding of a new era of patent law to protect IP in chemistry, pharmaceuticals, biotech, and genetic medicine. For today's presentation, Dr. Nicholas Lanzatella will provide tips on how you can maximize your chances of obtaining broad protection for inventions that include chemical features. Nicholas, I'll let you introduce yourself and take it from here.
Hi there. Thanks for the nice introduction, Brian, and thanks to everyone attending the webinar. So I'm a chemical patent attorney at the firm. I have a PhD in organic chemistry, a bachelor's degree in chemical engineering, and I specialize in what I usually called applied chemistry or chemistry in an engineering context. I consider this to be generally non-pharmaceutical chemistry that usually involves, often is combined with a mechanical feature, but not always. So things like polymers, adhesives, films, but also things like composites or mechanical devices that have special coatings, for example. So the things I want to talk to you about today are mostly born out of my experience and practice over the last 8 years in this area of technology. I often deal with mechanical and chemical subject matter intertwined, so I'll be frequently discussing the difference between those types of subject matter, although I simply pick mechanical as an example. Computer or electronics would also suffice, and as far as a chemical feature, what I really mean is generally life sciences features, but since I'm a chemist, I say chemical feature. So let's start off with some basics. What is a patent? A patent is a right to exclude others from making, using, or selling what you've claimed in an issued patent. It's not a self-enforcing right. In order to make someone stop, you need to sue them for patent infringement, and you need to win. In order to get the patent right, you need to file a patent application. After that time, something called patent examination occurs, which is an adversarial process that occurs between the applicant, usually by way of their patent attorney, and a patent examiner. During patent examination, a patent examiner tries to find reasons why the patent shouldn't be granted, and the applicant argues back for reasons why it should be and amends the claims, and eventually the patent examiner agrees that the patent should be allowed to issue. Some of the major issues that occur during patent examination, the main issues involve prior art. Prior art are documents that were published prior to the filing date of your patent application. The examiner will attempt to show that your claimed invention is known from the prior art and therefore does not deserve a patent. The two main ways to do this is by a novelty rejection or an obviousness rejection. And these words have specialized meanings in patent law that don't necessarily accord with our everyday use of these terms. So novelty is the easy one. This means that all of the features can be found in a single reference. If an examiner can do this, an examiner can reject you for lack of novelty. So for example, if a claim recites features A, B, and C, if an examiner can find all of features A, B, and C in a single reference, the examiner can reject you as lacking novelty or as being anticipated over that reference. Obviousness is a bit more complicated. It's called inventive step usually outside of the United States. In obviousness, the idea is that all of your claimed features are found in a combination of references instead of just one reference. So back to our example, if we claim A, B, and C, A and B could be in one reference, C in another reference, and an examiner could reject you as obvious over that combination of references. So how do we overcome obviousness? Well, the easiest way is to simply show that you've claimed a feature that's not disclosed in the combination of references. However, sometimes this can be difficult. In the mechanical arts, I would say it's a frequent way of overcoming an obviousness rejection, but sometimes in the chemical arts, it can be less common. You might imagine that if I add a feature to the claims that's not disclosed in any of the references, well, why couldn't the examiner simply find another reference that just discloses that feature alone and add it into the rejection? And indeed, that's exactly how prosecution often unfolds if we only follow the first strategy of showing not all features are disclosed in the combination of references. So this seems like a way an examiner could almost always win unless I'm using a feature that's never been seen before in any context. So in fact, there are other ways to overcome obviousness. An examiner is not allowed to simply blindly combine references. In fact, the examiner needs to show that the invention is actually predictable from the cited references, that one of ordinary skill in the art having the references in hand would actually be motivated to combine those references and combine the elements as you've claimed them to accomplish your claimed invention. So this gives us a couple of avenues for attacking the rejection. For example, we can show there's no motivation to combine the references. For example, if the references involve completely unrelated areas, we can make this type of argument. Another effective argument is that the references teach away from the claimed invention. Sometimes this can be hard to show. When you can show it, it's very powerful. But the problem is that even poor results still constitute a disclosure. A reference actually needs to explicitly disparage something for it actually to be considered to teach away from the claimed invention. So another way to show that the invention is not predictable, and in fact the main point of my talk today, is you can demonstrate that your claimed invention has advantageous properties that are not predictable from the combination of cited references. These properties don't necessarily have to be recited in the claim. They can be simply a property that occurs when you have an invention that has all the features you've claimed. So oftentimes in prosecution, when I'm going to advance this type of rebuttal to an obviousness rejection, I quote the MPEP, a rationale to support a conclusion that a claim would have been obvious is that all the claimed elements were known in the prior art, and one skilled in the art could have combined the elements as claimed by known methods, with no change in their respective functions, and the combination would have yielded nothing more than predictable results to one of ordinary skill in the art. I really like this passage because I really think it underscores this idea that if I combine things and something that I couldn't predict happens, then that means that we've overcome the obviousness rejection. And oftentimes in this presentation, I'll talk about those unpredictable results as being advantages. I think it's better to characterize something predictable as an advantage. And really any property, if you think hard enough, could generally be characterized as an advantage. And it usually looks more appealing to the examiner when it's not simply an unpredictable feature, but it's also an advantageous feature. So usually the way I'll describe this is an advantageous, unpredictable feature. So the ability to show unpredictable advantages is not unlimited. In fact, there is a rather standard way that examiners attempt to respond to this. And that response is to show that one or more of your claimed features are result-effective variables. This is another phrase that has a very specialized meaning in patent law. A result-effective variable means that basically an examiner has shown that the prior art teaches that if a particular feature of your claim is varied, it has some kind of an effect that's related to the advantage that you're trying to argue for. So, for example, let's say that you are claiming a process to make a polymer that has superior whiteness, and you've discovered that a particular concentration range of a certain whitening agent leads to an optimized or higher than ever observed before whiteness in this polymer. Let's say you're going through prosecution and the examiner has identified the whitening agent and the polymer, but has failed to show the use of that specific concentration of the polymer that you've optimized. So you could argue that that polymer gives the unexpected result of superb whiteness that's never been seen before in the prior art. The examiner could come back and say, well, yeah, this is if the examiner can find it. Such and such a reference shows that if I vary the concentration of your whitening agent in the polymer you're claiming, I can have some kind of effect on whiteness. Now the key here is it doesn't actually have to be used in the concentration I'm claiming at. All the examiner has to do is show that if I vary it, it has some kind of an effect on whiteness, and then the examiner can argue that one of ordinary skill in the art then, using very little skill, little or no skill, could perform routine optimization using that feature until the optimal whiteness is achieved. So how do we overcome this result effective variable position from the examiner? Well, there's two basic ways to do it. Either you can show that the prior art fails to correlate the feature to the effect. So in my example, we could go back and attack the examiner's arguments that the cited references teach an effect, some sort of an effect on whiteness when I vary the concentration of that whitening agent. Maybe the data doesn't really show that very well. And we could show, and we could tell the examiner that no one of ordinary skill in the art ever would have thought to vary that to affect whiteness. So that's one way to attack it. Of course, another way to attack it is to amend another feature into the claims that is not correlated to the effect. So, for example, in our whitening example, perhaps in our examples we haven't just shown that one whitening agent generates the outstanding effect, but in fact it's a combination of two whitening agents. And perhaps the prior art is silent about the effect of the other whitening agent's effect on whiteness. In a situation like this, we could overcome this rejection by amending the second whitening agent into the claims. One tip is to make your comparative data as specific as possible. I think if your comparative example is general, for example, it simply shows an advantage caused by adding a mixture of materials instead of sort of teasing out what element from that mixture, what component of that mixture is causing the advantage. It can be easier for the examiner to show that using that mixture or using some component of that mixture would be result effective from the art. If you're very specific about what component of the mixture causes the advantage, I think you have slightly more ammunition when heading down this road. So let's try to think about some examples of potentially unpredictable properties in different types of subject matter. So for example, we'll start off with mechanical. We could imagine that a machine we're claiming could have an unexpected advantageous property, such as the machine is more efficient, so it does something using less resources, perhaps like starting materials or electricity. A machine could be stronger or more powerful, could be cheaper to manufacture. However, any of these things can be hard to show sometimes in the mechanical arts. Cheaper to manufacture, well, maybe that's just because you use cheaper materials. Stronger, more powerful, stronger materials could result in that. It's pretty easy for an examiner to show that some of these things are result effective. And for that reason, I think it's less common in the mechanical arts to overcome an obviousness rejection using unexpected properties, as I'm advocating in this presentation. Let's look at chemical subject matter. So an easy example is just simply some compound or material, known or unknown, has some property that is just not predicted from any published reference. This could really be any property you can imagine, We can even make up new properties specific to whatever application you're looking at. But for example, we could talk about how strong something is. That could be a material or perhaps a bond between two materials. How elastic is something? How well can you see through it, or how transparent is it? How sticky is it? How adhesive is it? Any ability to do anything better, really anything we can characterize as an advantage. Another powerful advantage that sometimes emerges in chemical inventions is this idea that you have a feature, a property, that when two components are used together, that property is better than you'd expect from what the property is using each of those components on their own. So essentially the combination gives a synergistic effect that's greater than the sum of its parts. That can be very powerful. That can be very difficult for an examiner to rebut using the result effective variable route. So for a method of making something can be more efficient, or it can generate a material that's better. It could be purer or require less purification, or can have some advantageous property like superior whiteness, for example. It could do anything better. So what should emerge here as we look at mechanical versus chemical is that it's a lot easier to think of things that are unpredictable in life sciences subject matter as compared to mechanical. And again, I pick mechanical simply because I encounter mechanical plus chemical all the time in my practice, but this also applies to electrical and software. So why is this? Indeed, if you look back at legal writings, you'll see that there's a history, in fact, of referring to mechanical arts as predictable arts, and chemistry and other life sciences as unpredictable arts. And if we think about this, to some extent, this makes sense. Mechanical arts, there's really no mystery about what's happening in a machine. You can see it, you can hold it. There's really no part of it you can't characterize and completely understand. The way machines work is something we can see. Their properties are easy to ascertain. However, chemistry and other life sciences, including biology, are considered to be unpredictable arts. And this is despite today's day and age of incredible technological revolution, despite all the modern methods at our disposal for looking at a chemical compound and characterizing it, or looking at a chemical reaction and trying to understand what's happening. There's still an element of mystery to the way that chemicals and biological materials work. You can't see them. They're so small that even if you were the same size as a molecular atom, you wouldn't be able to see everything that's going on. There's an element of chaos and unpredictability, an element of sort of an infinite number of things occurring at once, and what actually is it that predominates and causes the global effect. It can be very difficult to predict things from such complex systems as what we have in chemical and biological inventions. So what does this mean? This means that when you have an invention that has any chemical feature in it, I think it's important to give yourself the maximum chance of the broadest claims possible to capitalize on that. And that means a couple things. Well, first of all, you need to recognize you have a chemical feature. So some feature of the invention that is a material or chemical compound, and ideally, it's a feature where you can test it against the prior art, basically compare it to the prior art and show that something is better as a result of that chemical feature. These are the situations that you really want to capitalize on those features. So a couple general tips here, and these extend outside of exactly what I'm advocating in the presentation here. I think this is always good practice, but it will help you if you want to use some of the techniques here also. So it's very important, I think, in the example section that you do as good a job as you can describing both your starting materials and your product. And this is in terms of not only what it is, but what its properties are. A lot of times I see inventors submit a disclosure that describes how they did something that's entirely built from trade names, and it doesn't disclose what the actual chemicals were that were mixed to make the invention. In most situations, I think that type of experimental write-up needs to be fixed before it goes into a patent application. The trade names need to be removed, ideally, and you should be able to specifically describe exactly what chemicals you put in there. And I think it's also important for whatever products you make to include as much characterization data as possible. You just can't tell which of that data is going to be useful later. On to things that are a little bit more relevant, though, and on point to what I'm advocating today. Yeah, I think it's really important to include comparative data. Comparative data is really the gold standard for showing that some advantageous property results from one or more of your claimed features. At the bare minimum, you want to compare basically a variation of that's something that's just like your invention, but that's the closest thing in the prior art. So you have your prior art comparative example that measures the property, and then you have your working example. And the only difference between the prior art comparative example and the working example should be the one or more features you believe are responsible for the advantageous property. And it shouldn't be just what you believe. The example should show that. You should have characterization data that shows that the result of following your claimed invention results in something with superior properties to the prior art. That's the bare minimum one comparison. An even better situation is to try to show what scenarios that effect holds true for. Like preferentially, you show it holds true over a wide variety of circumstances. So, for example, if you have a beneficial effect of some component mixed with other components, it would be good to vary the concentration and show that the advantageous property still occurs. It would be good to vary the other materials in the mixture, for example, different types of additives, the concentrations of other materials in the mixture, or even the chemical identity of other materials in the mixture, by showing that your advantage is operable over a wide variety of conditions. This can convince an examiner to allow you to claim your advantageous feature very broadly. And another thing that's important to do, and I often, I sometimes see applications hit my desk written by non-chemical attorneys that have problems. And one of the major problems I see is that even when comparative data is present, we'll have an application that has nice examples that shows some specific compound has some great effect, but then the claims and the application itself maybe disclose one broad term for that feature, for going back to our white polymer example, a whitening agent, and then go straight to the narrow, the exact compound used in the examples. So ideally, whenever you have a feature that you have this great data showing it's an advantage, the application should flesh out that feature from broad to narrow in order to get the broadest protection possible. The examiner is probably not just going to allow you to claim any whitening agent. All the examiner has to do is find one whitening agent that falls between your broad description whitening agent and the specific chemical structure in your example, and you would be forced in that situation to narrow the claim down to your specific chemical structure. What you really need is to flesh out that whitening agent from broad to narrow. The verbal description whitening agent, then you ideally should have a broad chemical structure that encompasses the whitening agent and other whitening agents you believe might also have the advantageous effect, and there should be a series of narrower and narrower structures until you arrive at the most specific structure. This is the technique you want to follow to get the broadest claims possible when you have a chemical feature that leads to an unexpected advantageous property. So, summary of my points today: you can show unexpected properties from claimed chemical features to overcome obviousness. These properties don't have to be in the claims, but they can be. It's easier to show that chemical features give unexpected properties than other types of features. So if you have chemical features, you should be thinking about this. if your invention has a chemical feature, you really should flesh it out from broad to narrow for maximum value. This may take a little extra time, and you may need to find a patent attorney that can do this, but it's oftentimes worth your while to get the most value out of that patent application, to get the broadest claims possible. And finally, it's important to encourage inventors to gather that comparative data. It's very difficult to do that last second. It's something that really needs to be an integral part of the research process. Sophisticated clients I work with know this. They teach their inventors early on to do this, and usually once the invention hits the disclosure stage, it's loaded with comparative data. Your IP at your company will grow more quickly and be more powerful if you can also educate your inventors to include gathering comparative data as part of their research process.
Thanks, Nicholas. If anyone has any questions, feel free to use the Q&A or chat feature. The next presentation that we'll have is going to be on November 9th, and that's going to be 5 patent prosecution tips for polymer tech. We're going to try holding a webinar once a month within this series. So we'll take a few seconds, and if you have any questions, feel free to use the Q&A or chat feature. Thanks. We got one question coming in. When is it important to document in lab notebooks and witness?
So the question is, when is it important to document in lab notebooks and witness? You know, I think the rules on that vary from country to country. I think it's generally good practice to document your research every day and have witness signatures. I think that ensures that your data will withstand scrutiny in a variety of jurisdictions. So the question is, what about introducing unexpected features not in the case with a Rule 32 affidavit? So you can introduce unexpected features without any declaration or affidavit. This can be something that's simply shown in your examples. Certainly you can use declarations to add inventor comments about how unexpected things are. Generally, you want to avoid declarations unless absolutely necessary. I do see folks trying to use declarations as a quick way out. Sometimes I discourage that. Declarations, affidavits are something that can be attacked later on during litigation. It's one of the first things a litigator will look at and scrutinize. Definitely could be considered a weak point. So I would avoid this if possible and try to get everything you need for the advantageous features into your examples. Don't treat the prosecution process as a way to add data later. You should try to get everything that's important into the actual application. So another quick question, just back to the question about when is it important to document lab notebooks and witness. Keep in mind the United States is now a first to file jurisdiction. So there's never going to be a situation where you're going to be arguing about who wrote something in a lab book first. I still think it's important to document your data and initial it. There's other reasons why you might want to prove that, but as far as proving who invented first, which has in the past been a reason to document your research, that's not really going to be a reason anymore, but you should still do it. That's my opinion on that. Looks like we have another question here. Can you speak to developments related to inherency and obviousness? Anecdotally, I've noticed an increase in rejections where examiners rely on inherency. Have you also seen this? And what are your thoughts on response strategies? Right, so that's a very good question, and actually I could have devoted an entire slide to this. So inherency is when you say that something had the property even though it's not disclosed in that document. So for example, let's say some document makes the thing you're claiming, and you're saying, yeah, but I'm claiming this has exceptional strength, and the examiner can point at that reference and says, well, the reference made the exact same thing as you, therefore it must inherently have all the same properties. So a lot of times when you try to argue unexpected results, the examiner will, there'll be it's an obviousness rejection, so you have two different, or at least two different references, and the examiner will try to say, well, if the features were combined, then you inherently would have the advantageous effect. No, Mr. or Mrs. Examiner, that's not an acceptable argument, because in order to get that inherent effect, that person of ordinary skill in the art would need to combine those two references in the first place. So whenever an examiner tries to advance an inherency argument in an obviousness situation, your response should nearly always be, that is impermissible hindsight. The only way that inherent feature would have been realized by that person of ordinary skill is if they actually combined the references. That's a very good question, and it's something important for people practicing in this area to recognize. There's a question, how about for collaborations between multiple companies with only confidentiality agreements, but no agreement in place for splitting IP rights? Would a lab notebook help in that case? Well, maybe. I could imagine situations where it might, it's very hard for me to answer that. Well, I mean, my first reaction, there should be an agreement in place for splitting IP rights. That shouldn't be the inventor's responsibility to simply document everything carefully. But in any case, I think you should always document your research carefully and get witness signatures if you can. It should be a daily activity. It would really depend on the circumstance, the answer to this question, whether that would help as far as splitting IP rights. Sorry, I couldn't be more precise there.
All right. I think that's all we have. If you guys think of anything else, feel free to contact Nicholas, and we hope to see you at next month's webinar. Thanks so much. Bye.